A judge slapped Karoline Leavitt, the White House press secretary, with a $3,200,000 fine right in court. But minutes later, Attorney General Pam Bondi had her team step in to turn the tables. You won't believe what just happened. Before diving into the story, comment where you're watching from and don't forget to subscribe so you won't miss the latest stories. It was supposed to be a routine morning inside courtroom 7B of the federal courthouse in Sacramento, California. Rain tapped lightly against the windows. The clerks shuffled papers. Reporters sat bored, adjusting their cameras and sipping coffee from paper cups. Then the door opened, and Karoline Leavitt walked in alone. No security detail, no legal entourage, just a gray suit, dark tie, and an unreadable expression. People glanced up, curious but not shocked. Leavitt had been summoned for allegedly violating court protocol during a previous litigation hearing tied to her White House duties. According to the court's complaint, she disclosed sealed details from the proceedings during a press event weeks prior. It was a breach of conduct, clear and simple. Or so it seemed. Judge Susan Hartley presided that morning, sharp, precise, known for her no-nonsense attitude, especially when it came to high-profile personalities. She looked up from the bench, met Leavitt's eyes for a brief second, and immediately returned to her notes. "Karoline Leavitt," she began, her voice calm but firm, "you have been found in violation of federal court orders relating to sealed testimony. The fine is $3,200,000 to be paid within 14 days. There were no gasps, no dramatic pause. This was Karoline Leavitt after all, White House press secretary, media magnate. A few million wouldn't shake her. But something about the way she stood there, hands loosely folded, no reaction, no objection, caused a subtle shift in the room. Judge Hartley leaned forward, perhaps expecting a reaction. "Do you understand the terms of the judgment?" she asked. "I do," Leavitt replied, her voice level, "but I'd like to respond now." Heads turned. A few reporters straightened in their seats. The woman hadn't brought a lawyer, and here she was, asking to speak for herself in front of a federal judge. Judge Hartley looked skeptical. "Moz. Leavitt, I recommend legal representation before continuing. With respect, Your Honor," she said, "I think it's more appropriate that I handle this personally." She gave a slow nod. "Proceed." And that's when things began to shift suddenly. At first, Leavitt reached into her inside jacket pocket and pulled out a single sheet of paper. It was neatly folded, no binder, no folder. She placed it on the table in front of her. "I'm not disputing what I said publicly," she began, "but I am disputing whether the gag order applied in the context it was used." That raised eyebrows. "A legal gray area," she continued. "The order referenced in the contempt filing was tied to Section 35B of the protective hearing order issued on March 11th. But according to subsection 35B3, public safety exceptions permit disclosures under federal fair use exceptions, especially when the disclosed content refers to stockholder impacting risks. Judge Hartley blinked once. Reporters began typing. "I only mentioned one aspect of a process that, if misunderstood, could have been dangerous for public use. I didn't name names. I didn't cite protected documents. I referenced my own concerns based on what I saw firsthand," she said. The courtroom grew quiet behind her. A paralegal leaned over to whisper something to a colleague. Even the bailiff, who had been watching the door, looked slightly confused. Judge Hartley raised an eyebrow. "Are you suggesting that you're protected under federal whistleblower statutes?" "I'm saying," Levitt replied, "that the fine being levied against me may contradict precedent set in Stanfield v. U.S. Tech Holdings, 9th Circuit, 2004, where the court ruled that executive disclosures that serve a public interest cannot be penalized under seal protection if the statements fall outside the original parameters of the gag. There was a specific case, a ruling, a dated precedent. It wasn't a flamboyant gesture, it wasn't showmanship, it was strategic, calm, surgical, and now everyone in that room knew it. But Judge Hartley didn't like surprises in her courtroom, and Karoline Leavitt had just flipped the script. Judge Hartley didn't respond right away. She sat back, fingertips pressed together, staring at the woman who had just quoted circuit law like she belonged at the counsel's table. For a long moment, the only sound in the courtroom was the buzz of overhead lights and the occasional tap of a reporter's laptop keys. "Karoline," she finally said, dropping the formality for the first time, You realize that referencing precedent in this courtroom doesn't guarantee exemption? This isn't a theoretical argument, this is a federal penalty. Leavitt didn't flinch. I'm aware, but it's not theoretical if the penalty itself ignores its own framework. It wasn't what she said, it was how she said it. Calm, measured, like she had practiced the lines 100 times, but not in front of a mirror. It came from something else, certainty, not arrogance, not charm, just clarity. The courtroom's atmosphere had changed. The judge was no longer speaking at a woman accused of misconduct. She was debating someone who might actually know what she was talking about. A reporter near the back whispered, "Why didn't she bring her legal team?" Another leaned over. She must have wanted to make this personal. "Leavitt," Hartley said, slipping back into formal tone, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor, I'm requesting a reassessment based on Statute 1287F, Provision 4. I believe the court's penalty exceeds the bounds of what that statute allows in cases where sealed disclosure is nonspecific and intended to address imminent public concerns." She paused. "And I can provide examples of rulings that echo that logic." Judge Hartley exhaled. "You're serious? I wouldn't be standing here if I weren't." There was something slightly off-putting about it, not disrespectful, never that, just unusual, like watching someone recite rules in a game they weren't expected to understand, let alone win. She motioned for the clerk. "Bring me the transcript from the March 11th hearing and get the full ruling from Stanfield vs. Tech Holdings on my desk by this afternoon." The clerk stood and disappeared down the hall, leaving a sudden quiet in the room. "Karoline," she said again, this time like a parent trying to understand their child's logic, "you do realize what's at stake here. You're not just calling into question a fine, you're challenging the limits of courtroom discretion." She nodded. "Yes, but respectfully, Your Honor, if a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end?" A man from an oversight agency sitting behind Levit scribbled something into a legal pad. Another attorney quietly slid his phone out and started typing under the table. This was no longer a simple contempt hearing. It had become something else, a moment, a pivot. The kind of moment that law students wrote about years later when a defendant chose not to fight the accusation with lawyers or theatrics, but logic. Levit walked over to the side table, picked up a printed copy of the March 11th order, something she apparently brought herself, and handed it to the judge. "Pages 3 and 4, she said. "Third paragraph, you'll see the exception clause." Hartley didn't even look up as she took the paper. Her eyes scanned quickly, her lips pressing into a line. "This court has discretion," she said, "but even discretion," Levit replied, "has boundaries." No one spoke. Then slowly she looked up, not with anger, not even annoyance, just something close to realization. She didn't dismiss the fine, not yet. But something in her expression suggested the certainty behind it had cracked. But if Karoline had poked a hole in the dam, the real test was still coming. How far would the water go? By the time the courtroom reconvened after lunch, word had spread. Local journalists had already tweeted fragments of Leavitt's self-representation. National outlets began circling the hallway outside 7B, filled with camera crews, legal analysts, and people who never once cared about procedural statutes suddenly asking, "Can Karoline actually win this?" Inside, it was quieter but not calm. The air carried a strange charge, like everyone was holding their breath, waiting for a crack, a stumble, something to prove she was just another figure playing pretend in a courtroom. But she didn't stumble. Levit sat at the same plain desk, hands folded, expression blank. She didn't check her phone. She didn't look around. Just waited. Judge Hartley returned, holding a yellow legal pad covered in notes. She didn't sit right away. "I read Stanfield twice," she said, "and I reviewed subsection 35B of the gag order. You were right about the exception clause." A slight murmur stirred in the gallery, but she continued, holding up the copy Levit had handed her. "This exception only applies in cases where the disclosure addresses direct threats to public safety, not speculation. Your statements in that press event suggested a potential risk, not a confirmed one." She nodded. "That's fair, but the wording doesn't require confirmation. It requires good faith. That's a legal standard, and the court can't punish good faith disclosures that fall within that framework. Even if the concern turns out to be non-lethal or exaggerated. Hartley stared at her. You're walking a tightrope, Ms. Leavitt. I've walked narrower, she replied. A few chuckles slipped out in the back row. Even Judge Hartley allowed herself the faintest smile, but just for a second. I also reviewed your timeline, she said, returning to the bench. You made your comments 2 hours after the hearing. That timing suggests you may have spoken before receiving the full written order. Are you arguing you didn't have access to the language? Leavitt shook her head. No, I had access. But the hearing's oral summary was unclear. The clerk emailed the full transcript 6 hours later, and by then the press already had my statement. The courtroom hushed again. Judge Hartley leaned in. So you're telling this court that you accept responsibility for the timing, but not the intent? Exactly. I was trying to alert the public to a pattern I believed might pose long-term risk. It wasn't about ego. It wasn't about headlines. And the data I referenced wasn't taken from classified documents. It came from our own internal reviews. That makes it mine. A young lawyer in the gallery whispered to her colleague, "She's pulling apart every thread." Her colleague whispered back, "Yeah, and somehow it's holding." Hartley flipped through her notes again, then looked up. "You know," she said, "this court isn't in the habit of being corrected by civilians." Levitt replied without hesitation, "Then maybe the habit needs review." It was bold, direct, but not smug. The tone didn't come from someone who wanted to win an argument. It came from someone who believed the truth mattered more than who said it. For a few seconds, the courtroom was still. Not frozen, just still, like everyone had been knocked slightly off balance, but didn't want to admit it. The judge spoke again, slower this time. "You're forcing this court to consider precedent it hasn't had to apply in over a decade. I'm only asking the court to apply its own rules," she said. Hartley tapped her pen against the desk once, twice. "I'll take this under advisement. We'll reconvene in 24 hours for a final ruling. Until then, no further statements to the media. Understood?" She stood, grabbed her files, and walked out without another word. Levitt stayed seated for a moment longer, then calmly gathered her paper and left the room. Not like a woman who'd won, not like a woman who'd lost, just someone who'd said what needed to be said. But as she stepped into the hallway and saw the wall of reporters waiting, it became clear this wasn't just a courtroom moment anymore. It was about to become a national conversation. The next morning, the gallery filled before the doors even opened. Reporters were there 2 hours early, holding microphones and power cords like weapons, scanning the parking lot for a glimpse of the woman at the center of it all. Some people drove in from neighboring towns just to watch it happen. No seats were left unclaimed. Even Judge Hartley's own bailiff had to remind spectators that this was a federal hearing, not a movie. And yet, it was hard not to feel like something unusual was playing out. Levitt entered quietly again, dressed nearly identically to the day before. Same suit, same expression. But something about her presence had changed. She wasn't just the White House press secretary anymore. She was the woman who came into a courtroom and, by sheer force of logic and restraint, made a federal judge think twice. The attorneys seated behind the prosecution table had multiplied overnight. Now there were 3 from the original team and a new face from an oversight office. That alone spoke volumes. At 10:02 a.m., Judge Hartley entered and called the room to order. "I've reviewed the materials presented yesterday," she began, "and I've conferred with a panel of legal advisors from within the district." That sentence landed with noticeable weight. Judges didn't do that unless something deeply uncomfortable had surfaced. Karoline Leavitt's actions, she continued, did violate the spirit of courtroom protocol, particularly with regard to preserving confidentiality. However, the penalty initially assigned may have overreached the authority granted by the framework outlined in Section 35B. A pause. Murmurs. She looked at Leavitt. "Your reading of the exception clause and your reference to Stanfield were accurate, and though this court does not make a habit of overturning its own penalties lightly, the fine will be reduced from $3,200,000 to a symbolic $25,000, acknowledging both the violation and the legal argument that tempered it." No one clapped, but a ripple of shock swept across the room. Leavitt didn't smile, she didn't nod, she just gave a quiet, "Thank you, Your Honor." The judge wasn't finished. "I want to make something clear. This court is not granting you a pass because of your status or public profile. You earned this reconsideration because you came in prepared, respectful, and precise. That doesn't happen often, but it matters." A woman seated behind Leavitt leaned toward her husband and whispered, "I thought she'd be arrogant, but she's not. She's just different." The judge closed her binder. Court is adjourned. People stood. Reporters rushed for the exit to file their stories. Leavitt stayed in place for a moment longer, watching the judge leave. Then she turned, walked past the now silent gallery, and exited through the same door she came in. But outside those walls, the world was already writing its own version of the story. Headlines started appearing within minutes. Karoline Leavitt challenges court fine, walks out with a win, judge revises ruling after Leavitt's self-defense shakes the room. One woman, no lawyers, and a whole lot of case law. Pundits began debating, was this legal genius or just another example of the powerful playing by different rules? Did it show that courts were bendable if you're prominent enough, or that truth can still sway even the most rigid systems? Some believed Leavitt had staged the whole thing, an orchestrated spectacle to win public sympathy. Others believed the exact opposite, that she had been fully prepared to lose and simply spoke because it felt right. But one thing was undeniable. Everyone had seen it, not in a headline, not in a tweet, but in real time. A woman stood in a courtroom, challenged the very structure trying to fine her, and changed its mind, not with money or force, but with words. But as the noise outside grew louder, the real storm hadn't even started yet, because now the public had questions the system wasn't ready to answer. That same afternoon, Judge Susan Hartley sat in her chambers alone, with a cup of coffee gone cold and a legal pad filled with annotations she'd never expected to make. Her clerk had stepped out. Her phone buzzed with missed calls from law school friends and reporters she hadn't spoken to in years. She stared at the door for a long moment before turning back to the notepad. There, in her own handwriting, were 5 underlined words. She wasn't wrong, not entirely. Hartley wasn't new to controversy. In her 26 years on the bench, she'd handled racketeering cases, class actions against major entities, and disputes that drew national attention. But she'd never encountered someone like Leavitt, someone who walked into her courtroom, spoke plainly, and dismantled a multi-million-dollar penalty using little more than footnotes in federal precedent. And what gnawed at her wasn't that she had to reduce the fine. It was that Levit forced her to admit the court had possibly overreached. She pulled up the ruling again, Section 35B, Exception Clause Whistleblower Intent. There it was, clean, unambiguous, buried on page 4, exactly where Levit said it would be. She scribbled in the margin, "We missed this, why?" A knock at the door interrupted her thoughts. Her clerk returned with a small folder. "Judge," he said, "the Office of Legal Oversight called. They want a brief on the Levit adjustment by Friday, and Channel 12 is asking for a statement." She waved the second part off immediately. "No press." He lingered. "There's more. Law students from UC Davis are circulating the transcript. Professors are assigning it for legal ethics discussions. It's turning into a thing." She raised an eyebrow. "A thing?" He nodded, hesitant. "They're calling it the Sacramento defense. Like when a defendant flips a courtroom using the system's own tools." Hartley almost laughed, but didn't. "Close the door," she said quietly as it clicked shut. She stared at her screen. On it was the raw transcript of yesterday's session. Levit's words, calm, logical, strategically placed, stood out like highlighted lines in a textbook. She scrolled again, stopped on one part. If a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end? That one stuck because it was a question that had no easy answer, and every judge in the country would be thinking about it now. Across town, Levit sat quietly in the back of a small cafe off Capitol Avenue, staring out the window while her assistant spoke quietly into a phone nearby. She wasn't celebrating, she wasn't giving interviews, she was just thinking. A woman in her late 50s approached the table, holding a to-go cup. "Excuse me, ma'am," she said gently. "I just wanted to say, I don't know if I agree with everything you said in there, but I watched it online, and it mattered. The way you handled yourself, it mattered." Levit looked up, surprised. "Thank you," she replied simply. The woman smiled, nodded once, and walked away. There was no applause, no fanfare, just a small moment, a quiet one. Back at the courthouse, Hartley reopened a private memo from the district's legal review board. The last paragraph said it clearly. While the reduction in penalty was unexpected, it reflects the court's capacity to acknowledge its own limitations in the presence of well-founded legal arguments. This is not a mark of weakness, but a reinforcement of judicial integrity. She stared at that sentence for a while, then, for the first time all day, she allowed herself to breathe a little easier. But if a single courtroom could be shaken like that, what would happen when the broader legal system started paying attention? By the next morning, it wasn't just legal circles or headline writers buzzing. It was everyday people. Uber drivers talked about it between pickups. Barbershops in Sacramento and Roseville tossed around terms like gag order and whistleblower clause, as if they were recapping a playoff game. On a late-night AM station out of Stockton, a caller said, "I don't even like her, but what she did in that courtroom, that was something else." Cable news shows scrambled to book constitutional experts. Clips of Levit's courtroom appearance started trending, not because she was theatrical, but because she wasn't. There was no table slam, no outburst, just a woman calmly dismantling a fine she felt was unjust. And somehow, that was more captivating than any scripted drama. One segment on a national morning show ran a side-by-side comparison. Leavitt's transcript versus Judge Hartley's revised ruling. A former federal prosecutor shook his head on live television. She played the long game. She anticipated the counter-arguments before they even arrived. The phrase, Sacramento defense, began to show up in opinion columns. Editorial boards started asking hard questions. How often did courts issue fines without fully acknowledging legal exception clauses? How many people had simply paid because they didn't have the time, the resources, or the nerve to stand there and push back? Suddenly, Leavitt wasn't just the White House press secretary. She was a symbol of something people didn't even know they wanted. Proof that the system could still be challenged, and sometimes bent, if you knew it well enough. But of course, not everyone saw it that way. At the Department of Justice, an internal memo circulated, warning federal judges about the precedent this might set. While Levitt's conduct was non-traditional, her arguments, if not rebutted, could lead to more courtroom disruptions by high-profile figures choosing to self-represent, it read. A columnist in a San Francisco paper called it dangerous. We cannot afford to glamorize courtroom gotchas, not even when the person delivering them has influence. The law isn't a game. But others push back. A retired judge from Stockton penned a thoughtful op-ed. Karoline Leavitt didn't challenge the law, she used it. She reminded the public and the judiciary that no system is too powerful to be questioned. That's not rebellion. That's democracy functioning exactly as it should. Even some skeptics couldn't ignore what happened. At a downtown Los Angeles law school, Professor Joanna Mendez opened her civil procedure class by putting Levitt's transcript on the board. Like her or not, she told her students, this is how you speak when you've read every line twice. This is how you walk into a room where the odds are stacked and say, here's what you missed. Back in Sacramento, Leavitt remained quiet, no press tour, no public statement. She returned to work, business as usual, but her staff noticed a change in how people greeted her at meetings. More curious glances, more careful tones. One colleague asked, "Were you nervous in there?" Leavitt answered, "Yes." Did it show? I don't think it mattered. Because the truth is, the fear never stopped her from standing up and speaking. She didn't override the court. She didn't win by loophole. She followed the rules, she just read them more carefully than anyone expected her to. And that's what lingered. Not the money, not the cameras, but the idea that maybe, just maybe, knowing the rules could be as powerful as breaking them. But while Leavitt moved on, the system she challenged couldn't shake the moment, and its ripples had only just started to reach the surface. Weeks later, long after the headlines died down and the cameras moved on to newer, shinier controversies, the story still hung around, quiet but persistent. In offices and courtrooms across the country, judges mentioned the case in passing, law firms updated training modules, professors still slid Levitt's arguments into PowerPoint slides, titled, "When the Defendant Pushes Back." But the biggest impact wasn't in institutions, it was in people. Marcus Albright, a 34-year-old mechanic from Flagstaff, had never followed a courtroom story before, but he found a clip from the hearing on YouTube, 6 minutes of Karoline Leavitt talking with nothing but a piece of paper in front of her. No smugness, no shouting, just a woman making a point no one could ignore. Marcus didn't care much for prominent figures, but he watched that clip twice. Then he printed it and brought it into work. "Why would you print it?" his coworker asked. "Because if a woman like that can walk into a courtroom and tell the truth without hiding behind 30 lawyers, maybe I can speak up at my next union meeting without second-guessing every word." In Sacramento, a 62-year-old retiree named Barbara Levice filed a motion to revisit an old fine from a housing code violation she felt was mishandled. She brought up the Levit case to the judge. The court clerk, to her surprise, had heard of it. Her appeal wasn't overturned, but it was reviewed again. She got a partial refund. The message wasn't that Karoline Leavitt had outsmarted the system. It was that the system, when confronted with reason and calm defiance, could still pause, reevaluate, and admit error. That's what stuck. Inside the courtroom, Judge Susan Hartley's decision had nothing to do with admiration. It wasn't personal, it was structural. The facts stood, the argument made sense, and once she saw it clearly, she did what her position demanded. She corrected the course. But outside the courtroom, it didn't feel procedural. It felt like something else. A moment where accountability stopped being a one-way street. Personally, I think Karoline Leavitt's courtroom stand was a masterclass in courage. Facing a $3,200,000 fine with nothing but logic and a single sheet of paper takes guts. It's inspiring to see someone challenge a system that often feels untouchable, proving that precision can outshine power. But I get it if you disagree. Maybe you see it as privilege flexing its muscles, a high-profile figure bending rules most couldn't touch. Was this a win for justice or just a well-played loophole? I lean toward the former, believing it shows how knowing your rights can shift the game. What's your take? Did she redefine accountability or just dodge a bullet? Thanks for watching this wild ride with me. Drop your thoughts below, hit that like button if you enjoyed it, and subscribe for more stories that make you think. See you in the next one.